My name is Edward Phillips. I'm a partner in the Cramer, Rayson LLP law firm here in Knoxville. It is Friday, September 21, 2012, and I have the pleasure and honor to introduce one of my good friends and senior partner and mentors, a man who has practiced law in Knoxville for over 60 years, a person who has been very influential in my life, both personally and professionally, and that man is Ed Rayson. I have practiced with Mr. Rayson for a little over 32 years, and there's about several things I've learned from him, but four of them stand out. One of them is you can be a gentleman and still practice law and be effective. I don't believe I've ever heard Ed Rayson raise his voice to a witness, a client, opposing counsel, the court. Your word is your bond. There's no substitute for preparation, both in the amount of preparation and the detail. And the fourth thing I've learned is to be effective, you need to be able to be crisp and clear in the written word as well as the spoken word. And so now it's my pleasure to introduce Mr. E.H. Rayson. Would you tell us a little bit about your family history?
My mother and father were born in western Massachusetts. My father in 1896 and my mother in the following year. They were the children of immigrants. My father's parents came from northwestern England. My mother's parents came from Scotland.
What brought you from Earlville, Illinois to Knoxville, Tennessee?
Well, I had attended school in Northwestern my first year, and during the summer recess, I visited a friend of mine from LaSalle, Peru, Illinois, who had also been at Northwestern. We were each the son of a doctor, and we were each at the time contemplating medical school. He told me that he had learned that the University of Tennessee medical school admitted students after 2 years of undergraduate study. Most schools in those days required 3 years of undergraduate study. He said he was going to enroll in the University of Tennessee, and I went home that night and wrote to the University of Tennessee about a transfer. I wrote them in Nashville, Tennessee, which is how little I knew of it, but my letter got to Knoxville, and I was admitted to transfer there, which I did in September of 1941. My parents drove me down here. I enrolled. I soon became a pledge of the Sigma Chi fraternity, and I enjoyed that relationship very much. But in any event, my chance conversation with my friend in LaSalle, Peru, resulted in my writing and transferring to the University of Tennessee.
Obviously, you didn't become a doctor, so what happened along the line?
Well, I didn't do all that well in organic chemistry or in physics. And I enjoyed tremendously history courses that I took from Ruth Stevens. I therefore did not enroll in medical school. I probably couldn't have gotten in anyway with my performance in physics and chemistry. But I completed school in the summer of 1945.
You then joined the service?
I had worked at radio station WROL as announcer during the last couple of years I was in school. And in the process, I became acquainted with the Navy enlistment office, which was then in the what's now the old post office building. And I went by to visit him one day, and he told me that he would arrange for me to have a commission as an ensign in the Navy if I completed college and got a degree, which I did. And on the same day I was graduated, probably September of 1945, September 18, or maybe it was August, one of the two, I became an ensign in the Navy.
You chose or were put into a pretty interesting specialty, I suppose. Tell us what that was.
Well, it was a bomb disposal. I had, when I became active in the Navy, I went to Hollywood, Florida for 3 months training. And midway through that, I learned that in all probability I would be assigned to landing craft, and I would have but 5 days leave. But one day they announced to laughter that they would accept volunteers for bomb disposal work. I was the first in line, and the main reason was that I was going to get 2 weeks leave, and I was planning on being married during that leave, and 2 weeks seemed to be a better than 5 days had I gone to landing craft school. So after finishing in Hollywood, I spent 3 months in American University in Washington, D.C., where I learned about bombs, our own, not just bombs, but artillery as well, and those of Germany, which were very complicated, and those of Japan. Saipan had just been technically secured. I use the word technically because we were on the outside of the secured area where there were still Japanese. But we stayed there for a time, and then we left by a landing craft ship, 300 of us aboard, for Okinawa. It took us 2 weeks to get there, as I recall. We got there on the afternoon of a day. Our first air raid was that night, very thrilling. It wasn't much of an air raid as air raids go. There was only one Japanese plane, but it was close enough that you could see the red circle. It was caught in the stoplights. There were dozens, if not hundreds, of ships, United States ships, just west of Okinawa that opened fire on that plane, missed it completely, and that was about 6 o'clock in the evening. That plane, or some plane, a Japanese plane, came back that night, and we went over it again not coming close to the plane. But in those days, Japanese were attempting to strike American vessels. That plane came by, I would say, 100 yards behind our ship, not heading for a landing craft ship. That was not enough ship. But there were battleships, cruisers, destroyers, along with the landing craft. And it headed for one of them. As it was heading for one of them, not far behind our ship, the Japanese pilot, was caught by machine gun fire. I saw him attempt to get out of the plane. He didn't make it, and the plane crashed in the ocean. The following day, we landed on Okinawa, where we spent the first night walking or sleeping on the ground. I mention that because when I was told that I was going to Okinawa back when I was at Pearl Harbor, I had no idea of where Okinawa was until we located it on a map. But I was told that there were more poisonous snakes on Okinawa than in any place in the world. So I was not looking forward to a night of sleeping on the ground in a pup tent. But on one occasion, there was a dud bomb that came ashore. I located it, and for some unknown reason, although we had equipment by which we could unload it from a distance, I elected to unload it manually with a Stilson wrench. And I remember to this day how heavily sweated I became before that fuse started to turn. But it did turn, and I took it out and threw it away. But in any event, it was shortly after that that we went back to Pearl Harbor. We assumed, I think with considerable justification, that we were called back to lead the invasion of Japan, and then we were told that that was to be our function. So on August 6th, that was our state of mind, and that was the day that the atomic bomb was the first of two atomic bombs were exploded. And we, of course, realized that our role in the invasion was probably not to come to pass. And then there was a second one that went off. There was a lot of talk even then as to whether it was necessary. Certainly I think that the first one was necessary, and there was no moaning at the bar on that evening, I can tell you, since all of the bomb disposal officers would gather for drinks and on that day to celebrate what appeared to be the end of the war. There was also talk about the need for the second one, but there was no objection to it on our part.
I want to fast forward you now to the end of the war and the decision that you made at some point to return to the University of Tennessee. Can you tell us what was it that caused you to decide that you were going to go to law school?
Well, I considered three different things. I considered the possibility of medical school, but I was simply not terribly interested in it because I never had great interest in the courses that would have been required to get there. I also thought of going back and studying and getting advanced degrees in history. I was thinking of the possibility of entering the State Department and would get the degree to enable me to do so. And I considered law school. I visited my teacher, history teacher, Ruth Stevens, and told her of the paths that I was considering. She apparently understood that my greatest interest was in history. And she was ever so slightly profane a woman, which resulted in her reputation in that way. But she said, "Hell, Ed, don't be a teacher. You'll never make any money being a teacher. Go to law school." I entered law school that day, that afternoon. And law school, which had perhaps had a dozen or a few more than that students during the war, had over 300 students, virtually all of us as veterans of the war and beneficiaries of the program that paid our tuition and a slight monthly allowance in addition. So that's how I came to go to the University of Tennessee, and that was I think, a very wise decision.
This was a point in time, you have told me before, where you could actually take the bar examination before you graduated from law school.
Law school was a 3-year course. As I say, we were on a quarterly basis. And after completing 2 years, or 6 quarters, successfully, we were entitled to take the bar exam. Many of us did, and a few of us passed. So I became a lawyer in April of 1948 with another quarter or two to spend in law school.
Tell us about your first legal position, if you will.
In those days, I was acquainted with Arnold and Jack Cramer, each of whom was with the firm, and I knew them by reason of attending Church Street Methodist Church, as they did. So we socialized every now and then, even before I was in the firm. Andy had similar luck or bad luck in finding a position.
Andy Johnson.
Andy Johnson. So we decided that we would open up our own office. And I remember one day meeting Judge Jones on the street, and he asked us what we were going to do. And we told him we were going to practice law and open our own office. And his response was, "Who are you going to practice on?" Which was a very prophetic question, since we had very few clients and no big cases of any kind. Andy was 30 years of age at that time and was asked to work evenings at the General Sessions Court, which he did. We shared everything that came in. We decided at some point that we would establish a bar review course, bar exam review course. And we sat down and prepared 20 lectures. I think his wife typed them up for us. And we made known that this course was available. The law school supported what we were doing. We were 1 and 2 in the graduating class, so we had that reputation to go on. And the law school made available classrooms for us to give our bar review course. We charged $25 to take the course, and I think that in our first year we may have had 30 take it. So that was a nice cash crop, as well as the interesting prospect of the lectures.
How long did you and Andy Johnson teach the bar review course?
I believe that we did that for 3 years. We then gave it to a friend. In the meantime, I had been asked by Judge Wicker, or Professor Wicker, to teach labor law in the law school, which I did. And I felt that that was enough time spent on teaching. So we abandoned the cram course. Bob Crosley ultimately got it, and of course did very well with it.
So how did you become employed by Russell Cramer?
We heard one day that Charlie McNabb had been to the law school to inquire about our grades. And we didn't hear anything for a while, and Andy and I had talked about it. While our law practice was not all that great, we felt that it would come on eventually. And so we decided that unless he wanted both of us, we would remain where we were. One afternoon, as we were in the office playing chess, for lack of anything else to do, the door opened and Mr. Cramer entered. He had been pointed out to me at a bar function, so I knew who it was. And of course, as I said, Charlie McNabb, his partner, had been inquiring about our grades. So he got right to the point. He said he'd like to employ both of us. And we told him we would think it over, although we had already thought about that. And when he called us back, we accepted. That happened, I believe our first day was March 14, 2000.
No, 1949.
Yeah. Okay, and on the Saturday before that, I went in to take my books and other things to the office that I had been assigned, and I spoke to Mr. Cramer, and he told me then that he wanted me to concentrate on labor law. I had not taken labor law in college, but I had audited the course, and I had a paperback volume entitled The New Labor Law, which outlined the Taft-Hartley Act, which had amended the Wagner Act in 1948. He gave me an assignment that day. He had been asked by the Oak Ridge Hospital, which is different from the Oak Ridge Hospital now. He had been asked by the Oak Ridge Hospital to represent the hospital with respect to a petition for representation a union had filed. And while Mr. Cramer had done some labor law work, particularly for standard knitting mills, I don't know that he'd ever handled a petition for representation. And not only had I not done so, I had never heard it until he mentioned it. And that was on a Saturday. I went home and I got out my Taft-Hartley book. And as I've often said, on the second page I found the answer to my question, namely that the hospital, being not for profit, was not an employer under the Act. Therefore, the petition for representation would have had no applicability to the hospital. On Monday morning, I came in and reported what I had found. We went over to an NLRB office that was then in Knoxville, and they agreed with us completely, and the case was dismissed. I became an instant expert in labor law, and that's how that happened. So that was my start in the practice of law with Cramer, McNabb, and Greenwood.
You know, Mr. Rayson, I've told a lot of people that you and your brother John Rayson have been mentors to me my entire career. I would like for you to tell us a little bit about your mentor.
Well, I would have to say that Russell Reed Cramer was my mentor. He was 60 years old when I joined the firm. I was 26, the youngest in the firm. But as it happened, the labor law flourished. And Mr. Cramer left it to me to figure out what our theories were. But when it came time to go to court, he would come and I would instruct him on the case in the meantime. He would get the cases, and he represented Alcoa at that time, and he represented a company at Oak Ridge called Roan Anderson Company. Roan Anderson was to the community, then not a municipal corporation, but it was a community that Roan Anderson managed. The Atomic Energy Commission owned everything in Oak Ridge in those days, and Roan Anderson managed it. The police department, the libraries, the construction and maintenance of homes and office buildings, everything you can imagine, Roan Anderson did. Mr. Cramer had a contract with Roan Anderson whereby he would place 2 lawyers in Roan Anderson to do their in-house work. Their litigation work we did on the side, not under the contract. But to give you an idea of how heavy that was, the first case I had ever argued in the Sixth Circuit, the second NLRB case I had, and the first case I ever argued in the Tennessee Court of Appeals were on behalf of Roan Anderson Company. So I spent a lot of time in Oak Ridge working with Roan Anderson personnel on those and other cases.
Back to Russell Cramer for a moment. Tell us a little bit about that man as a lawyer.
Well, he was an outstanding lawyer. He had practiced law in Maryville in his beginning years. In 1935, he was asked to join a Knoxville firm. Poor Cramer, Cox, Overton, and Burnett, which he did. He practiced in those years. He had been primarily a plaintiff's lawyer while he was in Maryville. He told me that he had sued Alcoa every opportunity that he had. And at some point after he moved to Knoxville, Alcoa hired him. So his work became somewhat office work, although he remained a trial lawyer, and I considered him then and now as an outstanding trial lawyer.
How would he have compared with some of the greater trial lawyers of the day?
There were probably trial lawyers better known because of his work for such companies as Roan Anderson, Standard Knitting Mills, and Alcoa, which was to a considerable extent office work. But he was nevertheless an outstanding lawyer. He was outstanding because of his presence and his verbal skills and his ability to learn fast, which he did in the cases on which I worked with him. It was my good fortune that I could prepare the cases, write the briefs, and review the cases with witnesses. My role in the trials was always secondary to him, but nevertheless I had the benefit of doing what I did on the cases and observing what he did. We had many, many cases of all different kinds, many injunction lawsuits for companies out at Oak Ridge, and injunction suits for Alcoa, unemployment compensation cases for Alcoa. But nevertheless, he was still an outstanding trial lawyer, and I had the benefit of seeing him do it.
Mr. Rayson, you're currently been known, I think, as a management side employment lawyer, but that really wasn't always the case. In fact, probably between 1950 and mid-60s, you did more work for a union than most people would do in their lifetime. And I want you to tell us a little bit about the United Mine Workers.
Well, it was a very prominent union in those days, the wealthiest of all unions, headed by John L. Lewis, who was, I'm told, on the front page of the New York Times more in the during the 1930s than anyone other than Franklin D. Roosevelt. Very colorful man in manner and in appearance. Mr. Cramer had represented the mine workers in a murder case in 1941. I think it was tried at Tazewell. And Howard Baker's father was the prosecutor. The judgment was one of acquittal, but in any event, Mr. Cramer had performed work for the mine workers well before I had ever joined the firm. At some time during the either the late 40s or early 50s, he received a call from a man named Earl Houck. Mr. Houck was the director of the mine workers' legal department, and he came down to meet with Mr. Cramer. And after they were through, Mr. Cramer introduced me to him. The welfare fund of the mine workers, which was jointly managed by coal operators and the union, with John L. Lewis as its head, anticipated having a large number of lawsuits against companies who had signed the union contract under which they were obligated to contribute 40 cents a ton to the welfare fund for each ton of coal it mined, but who had failed to do so. Mr. Houck, on behalf of the welfare fund, asked Mr. Cramer if we would represent the fund in those cases. And also at that time, the union was being sued in interference cases where they would physically interfere with the work of some non-union mines. We agreed to do that, and I undertook both sides of those cases.
There was a case that you wrote up in your memoirs and under the caption, "A Reign of Terror in Campbell County." Would you tell us a little bit about that particular case? And
well, that was an expression local union or local newspapers used. About 100 coal miners met one day in Campbell County, and from there went over to Newcomb, down towards Caryville, up towards La Follette, going to non-union mines along the way and inducing them to sign the contract. They came to a mine about 4 or 5 miles north of La Follette that was owned and operated by a man named John Van Huss. John Van Huss was not a union miner. He had about 12 employees. They dug mines manually. But in any event, the gathering of coal miners from Jellicoe beat him up, buried him, dug him out, put him in a creek, took him out of that. I don't know how that finally wound up, but he was physically beaten. And 9 of those men were indicted in what was a capital offense, because they alleged that they had not only done that, but they had also taken property that belonged to John Van Huss. We were employed to defend those 9 men. it became noted that we were not only employed, but we were paid by the United Mine Workers with a fee to defend that criminal case. The case became assigned to a new new criminal judge in Campbell County, who happened to be a classmate of mine. The Van Husk case was the first case that he had ever handled as a judge. Ray Jenkins was employed as a special prosecutor, and we proceeded to defend the case. We spent the first week impaneling a jury. I did a lot of that myself. We then spent several days in the trial of the case. We had 5 lawyers on our side, one from each end of Campbell County, Roy Asbury being one, Britton Brown being one, Bill Turnblazer of the mine workers being one, and Mr. Cramer and I, the others. Mr. Cramer did the bulk of the trial work, and he argued the case for us. And Ray did the same on the other side. Ray was a very colorful man. I had seen him try a case before I was in law school. I had a roommate at the Sigma Chi house who told me that there was a very interesting criminal case going on and that I ought to go if only to see Ray Jenkins in action. And I did that for 2 days. The case was, the defendants in the case were the grandson of the man murdered and his housekeeper. The housekeeper was a mental woman. She was 40 years old with the mentality of a 10-year-old. The grandson was 18 years old. They fed him poison, the grandfather. They had a sense of remorse after that happened, and they tried to get the grandmother to vomit the poison. And to do that, they fed him raw eggs. That didn't work. The man died, and the case came on for trial. And I'll never forget, Ray Jenkins kept referring to the 2 defendants, he represented the grandson, as a 40-year-old woman child and an 18-year-old boy. And he argued that they had had remorse. And what did they do? They broke eggs for his old granddaddy. He said that a dozen times during the course of his closing argument, which must have taken at least an hour and a half. So that was probably my initial interest in law school. As I say, it was before my time in the Navy, and I didn't think about it until I was in the Navy getting ready to be discharged and wondering what I was going to do.
There was a piece of, I believe this was the Van Husk trial, there was a bit of cross-examination that I've heard you speak of that
yes.
I think is interesting.
He, of course, had the benefit of his many employees who could describe all that had gone on. We had checked on the employees, and we found one who had been convicted in earlier years of an infamous crime. In those days, if you had been convicted of an infamous crime, you could not testify in any case except in your own behalf if you were a criminal defendant. So one man came up to the witness stand and was sworn, and Ray started to examine him. Mr. Cramer got up and said, "I would like to ask some preliminary questions on Boy Dyer." And he asked the man if he had ever been convicted of a crime. The man was silent for a few minutes, and finally he said, "Age of consent." Age of consent was a crime, but not an infamous crime. And Mr. Cramer's next question was one of the great questions that I've ever heard in a courtroom. It was that with some relative of yours? The man we knew and had a copy of the judgment. He had been convicted of intercourse with his daughter. And as I say, that was an infamous crime. And Mr. Cramer no sooner got the questions out of his mouth than Ray jumped up and called for a recess. And we never saw that witness again.
Mr. Rayson, I doubt that there are very many lawyers that have participated in 4 trials and 4 cases, all of which went to the United States Supreme Court. And we can't go into the details of all of them, but give us a little summary of your work on those 4 cases.
The first one was Benedict Coal Company, a case that was commenced by the United Mine Workers Welfare Fund to collect monies that Benedict had not paid. Benedict countersued against the United Mine Workers, saying that the various strikes that they had entered into were in breach of contract, and the damages they sustained should be offset against what it owed to the welfare fund. We tried that case for at least a week in Greenville. It was a jury trial. The jury returned a verdict for the company for every cent that it had sued for. It had calculated its damages by reason of the coal that it had not been unable to mine during that period, and multiplying that tonnage by what it said it would have earned. One of our defenses that I had created was along the same line, since I had found that they were losing money on every ton of coal they mined, and therefore could not recover damages for those for the additional tons that it mined. The jury, however, returned a verdict for the company for every cent. We appealed that case to the Sixth Circuit. I argued the appeal on behalf of the welfare fund, and I also argued our theory of damages, why they could not recover damages in the amount they did. The lawyer that I was, or the judge that I was asking you about, wrote the opinion in the welfare fund part of the case, and he denied our theory.
Potter Stewart.
Potter Stewart Jr., right. We sought certiorari in the Supreme Court on behalf of both the union. The union was contending that it did not have a no-strike provision in its contract, which the court had ruled against us on. And
A certiorari was granted.
Certiorari was granted.
Did you work on the briefs in that case?
I prepared the briefs for the welfare fund. And I probably did some work on the mine workers brief.
What was the outcome of
the case was reversed. They found in favor of my theory on the damages issue, and they said that, or their opinion indicated that the union could only recover $18,000, not the $75,000 that it had. Of course, that was in a time when that was far more money than it is today. And but they also ruled that if the welfare fund was owed money, and it got a judgment for that, that the company would be unable to offset damages the union had caused against such a welfare fund.
Okay. Now the next case is United Mine Workers versus Pennington.
There are 2 Pennington cases. We referred to them as first and second Pennington. The first one was tried in 1961. Mr. Cramer was living at that time, and did the heavy end of the trial work. But this was an extremely important case, since it was a Sherman Act antitrust case. John Roundtree did the bulk of the work on the side of Pennington. That was also a jury case. The jury returned a verdict for the company. I can't remember the amount. It wasn't great, but it was under the Sherman Act, and they were entitled also to an attorney fee on that, and were left exposed to any number of antitrust cases. The court ruled that a union, although largely not subject to the Sherman Act, it was, if it agreed with a core group of employers to impose the same contract it negotiated with them against small companies that it bargained with. So that theory made the union theoretically liable in any number of lawsuits, and many such lawsuits were filed. We appealed that case to the Sixth Circuit. I think I argued second Pennington, but not first Pennington in the Court of Appeals. The case was reversed by the Supreme Court on an evidence ruling, namely that the companies and the union were entitled to jointly go before Congress to seek relief in a particular area, and the fact that they did so jointly did not constitute a conspiracy in violation of the Sherman Act, so-called Knorr-Pennington ruling, which is still a fairly prominent ruling. It was remanded for a new trial. Mr. Cramer became ill in 1965, if not earlier than that. He died in 1966. But in the meantime, we tried United Mine Workers against Gibbs in Chattanooga, and that was probably the last case in which Mr. Cramer played any kind of a role. His role in that was rather limited. Gibbs was a small coal operator. He brought suit for violent interference with his business, and he prevailed in the district court. Judge Frank Wilson was the judge in that case. He decided that he ruled not positively on the clear proof requirement of the Norris-LaGuardia Act, which we said was applicable, and I believe he found it applicable to a state law claim. That case was appealed to the Sixth Circuit. I argued it in the Sixth Circuit without success. We then petitioned for certiorari. We sought certiorari on two grounds, claiming that the court had no pendent jurisdiction of the state law on which the plaintiff had recovered, and furthermore that the court had not adequately ruled on the clear proof requirement of the Norris-LaGuardia Act. We had other grounds. I argued in the petition for certiorari that it be granted because of the closing argument of the plaintiff's counsel, which was incendiary to say the least. But it declined to grant certiorari on that ground, but it granted it on the other two grounds. As it happened, I wrote that petition for certiorari in the Hay Adams house in Washington, D.C. On one night, I wrote the principal arguments, which I remember well. I thought I was going to argue the case in the Supreme Court, but I wasn't. But it's interesting because I think that this was the sixth time I had petitioned the Supreme Court for certiorari in one of the mine worker cases. seeking certiorari on both the pendant jurisdiction and clear proof requirements. I came very close not to raising them in the petition, but I had written it so many times it didn't take me very long to do it, and so I put it in there, and the court granted certiorari. Shortly before the argument, I learned Willard Owens, a very good friend of mine and an in-house lawyer for the mine workers and the son of the treasurer, wanted to argue the case, and of course he was in control of the case and did so. He made a good argument. And the Supreme Court ruled that the court did have pendant jurisdiction of the case. It was entitled to exercise jurisdiction under state law on that theory, but that there had been no clear proof to establish the union's liability. The court, by its own order, dismissed that case, and so there was no retrial of Gibbs.
Which takes us to Ramsey versus United Mine Workers.
What?
Ramsey, that's the last one.
Ramsey was a non-jury case. I have frequently said that the best day's work I ever did was in preparation of Ramsey, in that there were about 14 different cases pending against the mine workers in Chattanooga. And John Roundtree wanted to try them all together. We finally talked it out, Harrison Combs and I, who was another in-house lawyer for the mine workers, and we decided that we would propose to Roundtree that he try those. We would agree to a consolidation of the 14 cases, but he would have to agree that we would try them without a jury. At that point, I don't know how many cases we had for the mine workers, with or without juries, but we hadn't won any of them where there was violence involved, as there was in virtually every case. He agreed to that. I say that our agreement to try those cases without a jury was one of the best deals that I ever made. So we tried that case. Took us about 6 weeks in Chattanooga, and we then submitted a brief about, I don't know how many months later, but each side submitted a brief. I still have a copy of ours in my desk in the office. It was 340 pages long. I think I interviewed or examined something like 75 witnesses in that case. I also got a fellow that had been an official with the TBA to explain the TBA's price structure for the purchase of coal. That had become significant in that the mine workers had covertly purchased the 7th largest coal company in the country, a company that was located in Kentucky, and had immediately made it a union company. That company had offered coal for 35 cents a ton or something like that for the, and Mr. Roundtree contended that it was a fighting ship. I obtained an excellent witness who fully explained the legitimacy of the coal prices that the union-owned company offered. And I felt that was one of the big reasons in Ramsey that Judge Wilson found that there had been no conspiracy in violation of the Sherman Act, and he dismissed the case. Huge case. The union's many $million treasury was on the line if we had lost that case. It was appealed. The panel 2-1 upheld the decision, or maybe it reversed the decision. I think that was it. I have been unable to know whether we sought en banc hearing or not. I can't find any brief that says we did. but I'm rather sure that we did. They heard it en banc. The en banc decision was it involved 8 judges, and they decided it 4-4, which reinstated the district court's judgment. Thereafter, the company petitioned for certiorari, and certiorari was granted. The union hired, for some unknown reason, although we'd had multiple successes at that time, including the Gibbs case and the first case we discussed, they hired Edward Bennett Williams to brief and argue that decision. He lost 5-4, and the court ruled that the way that Judge Wilson had utilized the clear proof rule was not appropriate in a Sherman Act case as distinguished from a state law case. The case was remanded to Judge Wilson. After multiple briefs, we were able to convince him that he would have decided the case in the same way had he utilized the preponderance of evidence. He agreed with that. The case was appealed to the Sixth Circuit, as I think I argued a part of that case, and it was again subject to a petition for certiorari. The petition for certiorari was denied, and so the Ramsey case won and became a victory for us. So I would say that the change in those procedures were the biggest change in the practice of law. As far as differences in the trial procedure, I think I'd try a case today, if I were able, in the same way I tried cases when I was a very young lawyer. The function of a trial, of course, is to persuade the court as to the legitimacy of your legal theories and to persuade the jury as to the legitimacy of what you say the facts are. And there may be modest changes in that, but essentially the trial of the case remains very much the same. There are those that say that in the earlier days the flamboyance of arguments existed, but it's no longer helpful. Mr. Cramer was of the old school, and he argued the case from the heart. He had the ability to cry. He had the ability to contort his face so as to indicate his great sympathy with the plaintiff if he was representing the plaintiff. There is a reported decision somewhere, a decision of the Court of Appeals, where Mr. Cramer, one of Mr. Cramer's cases had been appealed, and one grounds of the appeal was that he had cried to the jury and he had expressed an interest on behalf of God in the legitimacy of his case. The court ruled that if you have the ability to cry as an advocate, it is your duty to do so. And I don't think Mr. Cramer ever changed. He had the ability to cry, and he did so in many of the cases that I tried with him.
Mr. Rayson, you've received a lot of accolades over the years. You were listed in Best Lawyers since Best Lawyers' very first issue. You've been a Fellow of the American Bar Association, a Fellow of the Tennessee Bar, a Founding Fellow of the Knoxville Bar. Is there any particular award or accolade that you've received that you're the most proud of?
Well, as a matter of fact, yesterday I received a letter from Best Lawyers saying I had been selected for the 30th year. There's been nobody, I don't know that how many, if any others, have been selected for 30 years. That certainly, it was an honor when I first was selected. And so be that. I probably the award that I am most proud of is the Governor's Award that the Knoxville Bar gave me in 2001. That was, I was the only lawyer selected in that year. There's other lawyers who have also received that award, and I get together frequently for a lunch. But in any event, for my peers to have recognized me in that way was a great honor.
Is there anything else that you wish I had asked you that you would like to discuss?
My work for corporations. I think the year was 1948. I had a call from the personnel director of Union Carbide, and no, it was 58. He asked me if I would be interested in representing the company in a labor matter in Roane County. I said yes, and we have managed to represent Union Carbide and its successors unto this day. That work was significant but not heavy in the early years. I had the pleasure of working with Wilson Horde on what was one of the very first age discrimination cases. We tried that case before Judge Taylor, and he dismissed the case at the end of the proof. The case was written of in many of the textbooks because of the theory we had advocated that he adopted. I think that was probably in the 1960s, or maybe it was 1973. It was shortly after Wilson became chief counsel for Carbide. On my own, I represented the first company that I actually represented as my own client was the Knoxville Glove Company. Its owner, Rod Townsend, was a very close friend of mine, and we continued that work until his death.
Just to think of off the top of my head, Standard Knitting Mills.
Standard Knitting Mills was a major client, and my major work for Standard Knitting Mills was to advise and represent it in the course of elections. I think in one election there were 3,000 eligible voters, and there had been a number who had been challenged by the union as ineligible voters. The vote in that case favored the union, and so therefore the contested voters had to be ruled upon. We went through a lengthy hearing on that, and enough of them were found eligible so as to reverse the union's majority vote. But I think I had about 4 or 5 elections for Standard Knitting Mills.
Tell us about Levi Strauss and Company.
I started representing Levi Strauss in the 1970s. My work for Levi Strauss was labor relations work, some organizational work, and arbitrations of cases in which I had represented them in a pending arbitration.
What about Dempster Brothers?
Dempster Brothers was somewhat the same. I was in Chattanooga on one of the mine workers' cases when Jim Dempster called me, asked me if I would represent them. They were in the midst of an election, pending election, that they knew they were going to lose. And he wanted to hire me to undertake the representation instead of the fellow they had from Florida, and also to negotiate a contract with the union. I did that, and I continued to represent Dempster until they sold out. I don't remember the year, but they sold the company to Carrier Corporation. We did some work for Carrier Corporation after that. I represented Boeing at their plant in Oak Ridge. I represented the Charles H. Bacon Company, a manufacturer of hosiery in Loudoun County. Wise Iron Works. There were several companies of that sort, but my major companies, well, the Bacon Company was a major company because of family interest. But my major company was the whatever corporation was managing Y12, K25, and ORNL. We had some remarkable cases for them, including a case known as Barnador, which went on for, I think, about 8 or 9 years. And it was one of the more recent cases that I argued at the Sixth Circuit. The case was ultimately dismissed by the Sixth Circuit.
Now, my final question to you is this. What accomplishment during your career did you have that gave you the most personal satisfaction?
I would say that my last argument in the Court of Appeals of Tennessee, I was arguing a case on behalf of the Wilson family. They had sold property in Roane County along the Watts Bar Lake, sold 1,000 acres or something like that, a huge transaction, which had been challenged by an adverse possession lawsuit that involved not the entire tract, but what would have been an expensive tract had we lost the case. Poe Cooley represented the plaintiff. I represented the defendant along with Chip Finn. We won the case, and that was certainly a pleasure to me, not only because of its timing, but because of the relationship I had with the Wilson family. So that is the last case that I tried and argued, both before the Chancellor and the Court of Appeals. As I say, Poe Cooley was the opposing lawyer, and he is a splendid lawyer in every way and has tried ever so many cases.
Thank you, Mr. Rayson.
Thank you.